Greetings of the day. I am Anusmita Roy, and this video is pertaining to examination of witness under Section 164 of Code of Criminal Procedure. A statement made under Section 164 of the Code is admissible in evidence and may be used to corroborate or contradict a statement made in the court in the manner provided under Section 157 and 145 of Indian Evidence Act. However, the statement made under this section cannot be used as a substantive piece of evidence. A question may also arise as to why a magistrate is empowered to record statement in addition to the statements recorded by the police under section 162 of the code, and particularly when section 145 apparently does not distinguish between the statement under section 162 or statement under 164 of the code. There is no additional weightage given to the statements recorded under section 164 of the code for the purpose of contradicting a witness. The object behind it is that when 164 uh, is that during the course of investigation, police records the statement under section 162 of the code that they cannot be administered oath to the person making statement and cannot obtain his signature. But under section 164 of the code, a magistrate recording statement of a person can administer oath to him and obtain his signature over the statement. The person making and signing a statement before the magistrate during the course of investigation will not disown it and will support the case of prosecution. Certainly, if a person makes and signs a statement, then naturally he comes under moral obligation and chances of his turning hostile will be reduced. In the social conditions prevailing in our country, tampering of prosecution witnesses is favorite pastime. However, for the reason alone, their trustworthiness cannot be doubted. But the evidence of witness whose statement is recorded under section 164 of the code must be approached with caution. This, however, cannot invariably bear the rule of law when it is disclosed that a witness whose statement has been recorded under section 164 of the code was kept in police custody for several days and his whereabouts were not disclosed to the three relatives, and hence the evidence tendered by the witness in a court should not be relied upon. Similarly, a witness whose statement is recorded under section 164 of the code is not sticking to his statement so recorded, the court should not rebuke him and threaten him that he will be prosecuted or perjury for perjury. Statement given by a witness under section 164 CrPC is like a previous statement given during investigation. It is not substantive evidence adduced during the trial judge because it was not recorded in the presence of the accused but was recorded from a witness during investigation. It was recorded res inter alia acta, recorded behind the back of the accused. So, what is the need for this particular statement under section 164 of CrPC? The need for recording statements of a witness under this is twofold: to deter witness from changing their version subsequently, and second would be to get over the immunity from the prosecution in regard to information given by the witness under section 162 of the code. Another reason for recording statement of witnesses under this particular section is to minimize the chances of changing the versions by the witness at the time of trial under the fear of being involved in perjury. Now, I would like to discuss about the legal provisions of section 164, and the subsection 1 authorizes the magistrate to record the statement of a person or his confession no matter whether he possesses jurisdiction in that case. If he does not possess such jurisdiction, subsection 6 will apply. The word statement is not limited to statement by a witness but includes accused and not amounting to confessions. uh, Under section 2 there is a warning. So under the statutory provisions, the magistrate is first required to explain to the accused that he was not bound to make a confession and that if he did so it might be used against him. If this is the sine qua non for recording confession. The other mandatory requirement is that magistrate must put questions to the accused to satisfy himself that the confession was voluntary so as to enable him to give the requisite certificate under subsection 4. The magistrate must satisfy himself that no pressure or force was used on the accused who makes the confession. Bar against police pressure under subsection 3 of this particular section. It guarantees that the police pressure is not brought on the person who is willing to make a confession. Where the accused was in judicial custody for more than 2 days prior to the giving of the confession, it was held that the person is sufficient to shed fear and influence of the police, if any, and therefore the confession could be made voluntarily by the accused. Subsection 4 is the manner of recording of the confession, and it says that the confession should be recorded in the manner provided under section 281 and shall be signed by the person making it. The magistrate shall then make the memorandum at the foot of such confession. The magistrate cannot merely sign a printed instruction supplied to him. This will be violative of this section. The entire confession must be brought on record. The confession must be shown to be voluntary before it can be acted upon. The confession without memorandum that is voluntary is bad in law and cannot be admitted in evidence. So there's a question that whether the signature of the witness making statement is to be obtained. In view of the section 164 subsection 5 of the code, it appears that it does not speak as to whether the signature of the witness making the statement is to be obtained or not. In fact, it specifically states that the magistrate shall record the statement of the witnesses in a manner provided for the recording of evidence. While recording of evidence of a person, we obtain the signature of the person whose evidence is being recorded. That itself means that while recording a statement, there is need to obtain the signature of a witness who is making his statement before the magistrate. After recording such statement of witness, a magistrate should endorse his certificate at the foot of such statement. The statement recorded under section 164 of the code is the public document according to the section 74 of the Evidence Act. Such statement is admissible in evidence under section 80 of the Evidence Act. And going down to the next subsection, that would be 164 subsection 5 capital A. It is the recording the statement of victims of rape or a physically or mentally challenged victim. Subsection 5 capital A reads as a mandatory provision for recording the statement of the prosecutrix under section 164 subsection 5 capital A of CrPC by the magistrate. As soon as the crime is brought to the knowledge of the police officer, he is duty bound to take the victim to the nearest judicial magistrate for recording her statement. If the victim approaches the court for recording her statement, being distressed and aggrieved with the attitude of the investigating agency, thus it is the duty of the magistrate to record her statement. Further, this section also provides for recording the statement of temporarily or permanently mentally or physically disabled persons. In such cases, the magistrate shall take the assistance of an interpreter or a special educator in recording such statement. And further, it is provided in this section that such statement made by such person will be videographed. For all purposes, this statement shall be considered as a statement in lieu of examination in chief as specified under section 137 of the Indian Evidence Act, and the witness can be directly cross-examined on such statement. In case if the victim is a minor of the mother of the victim, it can be allowed to be present at the time of the recording under section 164 of the 164 statement. So these were the primary crux of section 164 of Code of Criminal Procedure. That would be all for today. Thank you for your patience and your time.